ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ಇವತ್ತು ಬಹಳ ಸಂತೋಷದ ಕಾರ್ಯಕ್ರಮ. At the very outset, I would want to thank the Honorable Minister of State for Information and Technology and Skill Development, who has played a pivotal role in making the Data Protection Act a reality today, who is also a Rajya Sabha MP from Karnataka and is most importantly a resident of Bengaluru South, our very own Shri Rajiv Chandrasekhar ji, for not only taking pains to make this act a reality today, but also attending the very first public engagement program being held in the country after the act has formally gotten the President's assent. Thank you so much, sir. I also want to thank Shri Sharad Sharma, man who wears multiple hats, a very respected technocrat who has always provided critical inputs to government to help in the country's digital transformation. I recollect with a lot of gratitude the multiple times that I have relied on him and his young team to advise me and other members of the Joint Parliamentary Committee on important facets of this bill at the time that the Joint Parliamentary Committee was discussing this bill threadbare. At more than 2 or 3 occasions, he and his team have come as witnesses before the JPC and have deposed and have presented their views, and many of the views have also found their expression in the today's version. ಬಹಳ ಖುಷಿ ಅಂತಂದರೆ ಈ ಬಿಲ್ಲು ಇವತ್ತೇನು ಆ್ಯಕ್ಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ ಬೆಂಗಳೂರದ್ದು ಬಹಳ ದೊಡ್ಡ ಪಾತ್ರ ಇದೆ. ಯಾಕೆಂದರೆ ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಈ ಇಡೀ ಹೋರಾಟ ಪ್ರಾರಂಭ ಮಾಡಿದ್ದು UPA ಸರ್ಕಾರದ ಟೈಮ್ನಲ್ಲೇನೆ. ಅವರಾಗಲೇ ಹೇಳ್ತಾ ಇದ್ರು, ಇವತ್ತು ನಮ್ಮಲ್ಲಿ ಬಹಳ ಜನ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಫ್ ಲಾ ಕೂಡ ಇದ್ದೀರಿ. ದಿ ರೈಟ್ ಟು ಪ್ರಿವಸಿ ಇಸ್ ಸಿನಾನಿಮಸ್ ಟುಡೇ ವಿತ್ ದ ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟ್. ಆ ಜಸ್ಟಿಸ್ ಪುಟ್ಟಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟು ಒಂದು ರೀತಿ ಗಂಗೋತ್ರಿ. ಅಲ್ಲಿಂದ ಆಲ್ ಆಫ್ ದೀಸ್ principles which were enunciated in the judgment found statutory explanations and regulations in the form of this act. So on behalf of a lot of young Indians, crores and crores of young Indians, and especially on behalf of young Bengalurians, we would want to thank Shri Rajiv Chandrasekhar with a lot of gratitude for leading this very important 21st century battle from the very front. Thank you, sir. Friends, both Sharad Sharma ji and Rajiv ji have highlighted the different facets of this act. Of course, we are looking forward to a very engaging question-answer session. This is a very interesting audience today. There are law students, there are young CEOs from startups in the city, there are very senior veterans in the space of data protection like Na Vijay Kumar ji, who is here, who has been working in this space from so many decades. There are journalists who have been working in this space. I'm sure this is going to be a very engaging question-answer session. I would want to keep my comments very brief. The very first aspect of this bill is the one that Rajiv ji was highlighting at the very end of his remarks. Yesterday, if you have observed the proceedings in Parliament, the Honorable Home Minister moved 3 very critical bills which are going to replace the foundational texts of the Indian criminal justice system. the Indian Evidence Act, the Indian Penal Code, as well as the CRPC form the foundational texts of the Indian criminal justice system. All of these three legislations were intended, legislated, and enacted by the British. The objective of the Indian Evidence Act as well as the IPC was to primarily serve the interests of the British Crown at the expense of the native population. It was not done to further the interests of Indians and the interests of the Indian government. So what the Home Minister essentially has done yesterday is to make a very important journey towards finally decolonizing India's criminal justice system after 75 years of independence. As students of law, you would all appreciate that even the drafting of the Indian Constitution was heavily inspired from both the Irish constitutions as well as the constitution of many common law countries across the world. And we borrowed liberally from the Government of India Act of 1935. So most of our legislation, starting from the Constitution to our penal legislations, we have done two things. ಮೊದಲನೇದು ನಾವೇನು ಮಾಡಿದೀವಿ ಅಂದ್ರೆ, ಬೇರೆ ದೇಶ ಈಗಾಗಲೇ ಮಾಡಿರೋ ಕಾನೂನನ್ನ ಫಾಲೋ ಮಾಡಿದೀವಿ ಲಿಬರಲ್ ಆಗಿ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಇನ್ಯಾವುದೋ ದೇಶ ಈಗಾಗಲೇ ಮಾಡಿರುವಂಥ ಕಾನೂನನ್ನ ಆಸ್ ಕ್ಯಾಚ್ ಅಪ್ ವಿ ಹ್ಯಾವ್ ಫಾಲೋಡ್ ಇಟ್. ಅಂದ್ರೆ ನಾವು ಬಿಲೇಟೆಡ್ ಸ್ಟೇಜಲ್ಲಿ ಫಾಲೋ ಅಪ್ ಮಾಡಿದ್ದೀವಿ. The DPDP is the first such legislation where we have neither played catch up to the other jurisdictions, nor have we liberally copied or borrowed from other jurisdictions. This is in every aspect a legislation made in India, made for India, and made by India. This is a very important aspect of this legislation. To be a little selfish, I would add that though this is made for India, it is largely made in Bengaluru and contributed greatly by people of Bengaluru. ಅದರಲ್ಲೂ ಒಂದು ಮುಂದೆ ಹೋಗಬೇಕು ಅಂದ್ರೆ ಬೆಂಗಳೂರು ಸೌತ್. ರಾಜೀವ್ ಚಂದ್ರಶೇಖರ್ ಅವರು ಅಲ್ಲಿ ಮುಖ್ಯವಾಗಿದ್ರು. ಶರದ್ ಶರ್ಮಾ ರೀತಿ ಬಹಳ ಜನ ಅದರಲ್ಲಿ ಟೆಕ್ನೋಕ್ರಾಟ್ಸ್ ಇನ್ಪುಟ್ಸ್ ಕೊಟ್ಟರು. ಶರದ್ ಶರ್ಮಾ ಅವರು ನಮ್ಮ ಬೆಂಗಳೂರು ಸೌತ್ ಅಲ್ಲೇ ಇರೋದು. ಅದರ JPCಯಲ್ಲೂ ಆಸ್ ಮೆಂಬರ್ ಆಫ್ ದಿ ಬೆಂಗಳೂರು ಸೌತ್ ಪಾರ್ಲಿಮೆಂಟ್ ನಾನು ಅದರಲ್ಲಿ JPCಯಲ್ಲಿ ಇದ್ದೆ. ಅಂಡ್ ವಿಟ್ನೆಸಸ್ಗಳಲ್ಲಿ ಬಹಳ ಜನ ಬೆಂಗಳೂರಿನವರು, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಲಾಯರ್ಸ್ ಹೂ ಆರ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಇನ್ ದ ಪ್ರಿವಸಿ ಲಾ ಡೊಮೈನ್, ಬಹಳ ಜನ ಬಂದು ಅದರಲ್ಲಿ ಡಿಪೋಸ್ ಮಾಡಿದ್ರು ಆಸ್ ವಿಟ್ನೆಸಸ್. ಸೊ ಇನ್ ದಟ್ ಕಾಂಟೆಕ್ಸ್ಟ್ ಆಲ್ ಆಫ್ ಅಸ್ ಕ್ಯಾನ್ ವೆರಿ ಪ್ರೌಡ್ಲಿ ಸೇ ದಿ 21st ಸೆಂಚುರಿ ಇಂಡಿಯಾದು ಟೆಕೇಡ್ನ ಲಾ ಒಂದು ಫೌಂಡೇಶನ್ ಕೊಟ್ಟಿರುವಂಥ ಕಾನೂನಲ್ಲಿ ಬೆಂಗಳೂರುದು, ನಮ್ಮ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆನ್ಸಿದು ಬಹಳ ದೊಡ್ಡ ಒಂದು ಪಾತ್ರ ಇದೆ. ಇನ್ನೊಂದು ಆಸ್ಪೆಕ್ಟು, a very interesting aspect of this bill is any legislation for a policy maker. ನಾವು ಲಾ ಅಲ್ಲಿ in the very first classes on law school, ನಮಗೆ interpretation of statutes ಅಲ್ಲಿ they start teaching us this concept of harmonious interpretation. The challenge for any lawmaker is how to harmoniously balance two apparently opposite concepts and objects. How do we balance two diametrically opposite ideas which are very much essential to make a systematic society run? This is a challenge for any policymaker. What the government led by the Honorable Prime Minister has done very successfully in this legislation is they have tried to and succeeded in harmoniously balancing privacy as well as processing, regulation as well as space for innovation and freedom, balance between the sovereign interests of the state as well as the individual rights of a private individual. This is something that this bill has so beautifully and successfully managed to address. Yake, I'll give an example. If there is blanket regulation that you cannot process data at all, what will happen to the 90,000 plus startups which have just entered the startup revolution? All of them will die a very natural death. So you need to make space for innovation. At the same time, you should also make space for protecting the privacy of an individual. This is balanced. At the same time, a government has many sovereign needs. For example, ಯಾವುದೋ ಒಂದು terrorist attack, ಯಾವುದೋ ಒಂದು ಮಾಡ್ಯೂಲ್ ಇದೆ, ಸ್ಲೀಪರ್ ಸೆಲ್ ಇದೆ. Just as we speak today, NIA has arrested 15 plus people in Bengaluru who are suspected of fomenting terror activities in the city. So whether it is preventing waging war on the state, whether it is protecting any of these very important sovereign interests, or maintaining the interests of a private organization or the privacy of an individual citizen. This is another very important balance that needed to be struck. E bill nalli, both of these very important aspects, ensuring that the government does not overreach and does not peep into our personal lives, as well as the fact that the government needs enough material, enough ammunition, enough strength to maintain law and order, peace and security and sovereignty, integrity of the country. That is also something that is taken care of in the bill. The other important aspect, Sharadji was mentioning about this in the course of his remarks. When the first version came, where Rajivji was also a member of the JPC, later he got promoted and the good fortune of contributing much closely in the making of the legislation. There were various categories of personal data that were envisaged. The earlier version of the bill. Personal data ಅಂತಂದ್ರೆ ಈ ಹಿಂದಿನ ಬಿಲ್ ಅಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಕ್ಯಾಟಗರಿ ಕೊಟ್ಟರು. ಕೆಲವುದು ಕ್ರಿಟಿಕಲ್ ಪರ್ಸನಲ್ ಡೇಟಾ, ಸೆನ್ಸಿಟಿವ್ ಪರ್ಸನಲ್ ಡೇಟಾ, ಈ ಥರ ಬೇರೆ ಬೇರೆ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಡೇಟಾನ ಬೈಫರ್ಕೇಶನ್ ಮಾಡ್ತು. And the original thinking was that certain aspects of personal data, which is not critical, which is not sensitive, can be processed here, some cannot be processed. ಈ ಥರ ಬೇರೆ ಬೇರೆ ಡಿಫ್ರೆಂಟ್ ಕ್ಯಾಟಗರೀಸ್ ಆಫ್ ಪರ್ಸನಲ್ ಡೇಟಾಗೆ ಡಿಫ್ರೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಆಫ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಹಾಕೋತಾರೆ. The second version of the bill that has now become the Act has completely done away with this concept of different categories of personal data. There is only one category of personal data, and it is all-inclusive category of personal data. So every aspect of personal data of every single individual, every single Indian, is to be treated with the same amount of respect and the same amount of sensitivity. This is again something which is very different from what GDPR or other jurisdictions have envisaged. This is another very important aspect. ಯಾಕೆಂದ್ರೆ ಇದರಲ್ಲಿ like Rajivji was telling, GDPR ಅಲ್ಲಿ ಹಾಗಿದೆ, ಇನ್ನೊಂದರಲ್ಲಿ ಹೀಗಿದೆ. We have gone a step further. We have said every aspect, every dimension of an individual's data is sensitive data. Every aspect of an individual's personal data is critical data. Therefore, there is no differentiation between the kinds of personal data in this. The other aspect, generally when laws are made regarding spaces like privacy or criminal jurisdictions, government and its instrumentalities and private organizations are generally treated differently. With government and its instrumentalities given a little more leverage, a little more liberal space to occupy. The difference in this bill is the rules apply as stringently to a government organization or instrumentality of the state as much as it affects or implements on any private organization in the country. So there is no artificial differentiation or a theoretical differentiation that is made between a government entity and a private entity. If Facebook does something wrong, it will pay the same penalty as if, say, a BSNL will do. So, this is another game-changing aspect that has been put in this thing. ಇನ್ನೊಂದು ಸರ್ಕಾರಕ್ಕೆ ನಾವು ಕೊಡಬೇಕಾಗಿರೋ ತುಂಬಾ ದೊಡ್ಡ ಕ್ರೆಡಿಟ್ ಅಂತಂದ್ರೆ the beauty of this legislation is from the first line to the last line, any person, even without a background in law, can read the legislation in one sitting and understand the whole of it. ಅಷ್ಟು ಸಿಂಪಲ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಈ ಲೆಜಿಸ್ಲೇಷನ್ ಬರ್ತದೆ. Legislations earlier would be written in the interests of lawyers. Legislation in this manner, in this case, has been written in the interest of the data principal or the citizen of India. So, special congratulations to the government, to the Prime Minister and his entire team of such efficient ministers, Andre, for making it a very simple legislation which does not even have a single proviso. This is the first legislation of this kind. Generally, you'll have seen there's a first line in every legislation, adra kelgade baratte, provided that, and then adra kelgade baratte, notwithstanding anything mentioned here in above, and then it starts. Really, any normal person will not even understand what this is. But this is a legislation where the language is simple, language is direct, and there is not even a single proviso in the whole of the legislation. This is a very important step towards maturing ourselves as a nation that drafts and legislates simple laws for the interest of the individual. This is another very important philosophical step the government has taken. The other thing, other 6 principles of the act, everything Rajiv ji has covered, I wouldn't want to repeat. I would only want to say this. Generally, ನೀವು ಇವಾಗ ಫೇಸ್ಬುಕ್ ಯಾವುದೋ ಒಂದು ಆ್ಯಪ್ ಡೌನ್ಲೋಡ್ ಮಾಡ್ತೀರಾ. ಆ ಆ್ಯಪ್ ಡೌನ್ಲೋಡ್ ಮಾಡ್ತಿದ್ದಂಗೆ ಅದು ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್ಸ್ ಅದು ಇದು ಅಂತ ಕೇಳುತ್ತೆ. ಲೈಫಲ್ಲಿ ನಾವು ಇವತ್ತಿನ ತನಕ ಒಂದೇ ಒಂದು ಸತಿನೂ ಆ ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್ಸ್ ಯಾರೂ ಓದಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಅದಷ್ಟು ಫೈನ್ ಪ್ರಿಂಟಲ್ಲಿ ಇರುತ್ತೆ, ಅದಷ್ಟು ಉದ್ದ ಇರುತ್ತೆ. ಎಲ್ಲರೂ ಅಂತ ಸ್ಕ್ರೋಲ್ ಡೌನ್ ಮಾಡಿ ಅಕ್ಸೆಪ್ಟ್ ಆಲ್ ಅಂತಂದು ಹೊಡೆದು ಮುಂದಕ್ಕೆ ಹೋಗ್ತಾ ಇರ್ತೀವಿ. ಬಟ್ ದ ಡಿಫರೆನ್ಸ್ ಇನ್ ದ ಕಮಿಂಗ್ ಡೇಸ್ ವಿಲ್ ಬಿ ದಟ್ ದ ಕನ್ಸೆಂಟ್ ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಟು ಬಿ simple, it has to be specific, it has to tell the individual why your consent is being sought, for what purpose it is being sought, for what duration it is being sought, and it must be communicated to the Indian citizen, not just in the English language, because it is a language of the privileged class in India. It must also be communicated in all regional languages recognized in the Constitution of India. There was this very interesting question, Rajiv ji, that came up in the course of our discussion in the JPC. This was from a member of the Congress party. He said the very concept of privacy is very elitist. He said that this legislation itself is for the elite. Because the poor man perhaps may be not concerned or maybe not even aware that there is a concept called privacy that exists. Perhaps nobody can be as far away from reality and far away from truth as that kind of a statement. Because privacy is the fundamental right of every single individual. And English ಬರ್ಲಿಲ್ಲ ಅಂತಂದ್ ಮಾತ್ರ ಅವನಿಗೆ ಪ್ರೈವಸಿ ಇಲ್ವಾ ವ್ಯಕ್ತಿಗೆ? ಸೊ ಈ ಬಿಲ್ಲಲ್ಲಿ ನಾವು ಮಾಡಿರುವಂಥ ಬಹಳ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಕೆಲಸ ಅಂತಂದ್ರೆ ಕನ್ನಡದವರಿಗೆ ಕನ್ನಡದಲ್ಲಿ ನೋಟಿಸ್ ಸಿಗಬೇಕು, ತಮಿಳು ಮಾತನಾಡೋರಿಗೆ ತಮಿಳಲ್ಲಿ ನೋಟಿಸ್ ಸಿಗಬೇಕು. ಯಾವ್ಯಾವ ಭಾಷೆ ಭಾರತದಲ್ಲಿ 8th ಶೆಡ್ಯೂಲ್ ಆಫ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ನಲ್ಲಿ ರೆಕಗ್ನೈಸ್ ಆಗಿದೆಯೋ ಆ ಎಲ್ಲ ಭಾಷೆಗಳಲ್ಲಿ ಈ ನೋಟಿಸ್ ಜನಕ್ಕೆ ಸಿಗಬೇಕು. ಇನ್ನೊಂದು ಲಾಸ್ಟ್ ಪಾಯಿಂಟ್ ದಟ್ ಐ ವುಡ್ ವಾಂಟ್ ಟು ಸೇ ಬಿಫೋರ್ we will take the question answer is this. Sharat ji highlighted this very important point, very critical point, and idanna for a long time we discussed, and avaru written submissions alli kottidru, and we discussed it in JPC. The game changing aspect of this bill is how this is going to be executed. Now you will all ask, generally in the course of our conversations we keep telling alva, India the ಕಾನೂನ್ಗೇನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಸರ್, ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ಮು, ಎಲ್ಲ ಕಾನೂನು ಇದೆ ಅಂತ. ಕರೆಕ್ಟ್ ತಾನೆ? ಈ ಥರದ್ದು ಒಂದು ಕಾನೂನನ್ನ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಹೇಗೆ ಸಾಧ್ಯ? ದಟ್ ಈಸ್ ವೇರ್ ದ ವೆರಿ ನಾವೆಲ್, ವೆರಿ ಯುನೀಕ್ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಕನ್ಸೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಹ್ಯಾಸ್ ಕಮ್ ಇನ್ ಟು ಎಕ್ಸಿಸ್ಟೆನ್ಸ್. ಸೊ ದ ಬಿಲ್ envisages a concept called a consent manager. This consent manager will essentially be a technical platform where every single Indian citizen who is essentially a digital Nagarik can enforce his rights and duties using the consent manager to act on his behalf. Now the consent manager will essentially be an application, correct me if I am wrong Sharaji, it will essentially be an application which will tell you which particular data fiduciary, that is a particular data application that is seeking your data, who is seeking your data, what is seeking, why is it seeking your data, what is the duration for which it is seeking your data. Just using the consent manager platform, which is by the statute itself defined as an interoperable platform, meaning it is like our UPI. So ನೀವು UPI ಗೆ ನೀವು Paytm ಅಲ್ಲೂ ಯೂಸ್ ಮಾಡಬಹುದು, ಫೋನ್ ಪೇಲೂ ಯೂಸ್ ಮಾಡಬಹುದು, ವಾಟ್ಸ್ಆಪ್ ಪೇಲೂ ಯೂಸ್ ಮಾಡಬಹುದು ಅಲ್ವಾ? ಅದೇ ಥರನೇ ಕನ್ಸೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಇಸ್ ಆಲ್ಸೋ ಗೋಯಿಂಗ್ ಟು ಬಿ ಅನ್ ಇಂಟರ್ಆಪರಬಲ್ ಪ್ಲಾಟ್ಫಾರ್ಮ್. ಅದು ಒಂದು ಪ್ಲಾಟ್ಫಾರ್ಮ್ ಇಟ್ಕೊಂಡು ಯು ಕ್ಯಾನ್ ಗಿವ್ ಯೋರ್ ಕನ್ಸೆಂಟ್ ಆರ್ ವಿತ್ಡ್ರಾ ಯೋರ್ ಕನ್ಸೆಂಟ್. You can monitor how your data is being processed, by whom it is being processed, for what period of time it is being processed. Is it being processed even after you have withdrawn consent? If there is a data breach, what to do? Who to approach? What is the redressal mechanism? All of these things can be managed using a consent manager application, which is a simple technological application which creates a happy marriage between technology and legislation. This is a unique innovation that is done only in the Indian legislation space today, and no other, whether the GDPR, the Singapore, the Australian, the American, no jurisdiction, no legislation has envisaged a technical solution to enforce the rights and duties of the digital Nagrik. This is the game-changing aspect of this legislation. ಅದ್ಭುತವಾಗಿರುವಂಥ legislation ಇದೆ, which is why you have not heard a single complaint about it from the usual suspects. So, as we are moving towards a $5 trillion economy, where $1 trillion will be fueled by India's digital economy itself, this is a landmark legislation which is going to pave the way and show the way for the rest of the world to follow, to regulate individual rights in a digital space. I would want to, on behalf of all of you, and on behalf of a very hopeful, very optimistic, very ambitious, very audacious, and a very youthful India, thank with a lot of gratitude our Honorable Prime Minister Narendra Modi for leading this effort to make the rights of every single digital Indian protected and show the rest of the world how this is done. And I want to thank Ashwini Vaishnav ji and Rajiv Chandrasekhar ji and all those people who labored hard to make this legislation a reality. I thank you once again for being such a wonderful audience today. Sansad Dhvani, sir, is a platform that we have created since I got elected as an MP. Ever since then, this is the 8th or 9th edition of Sansad Dhvani. Whenever there is an important legislation that the Parliament of India legislates, we organize a program of this kind in our constituency to create awareness among the public, because the law is made for the benefit of the people and it is the people who empower us to make the laws. So it's a platform for accountability of public, and I'm extremely happy that just this morning, when the Honorable President of India has given her assent to the bill and made it an act, Bengaluru South is debating, discussing this very important legislation. Once again, thank you, Rajiv ji, for making time for this. And Sharad ji, thank you so much. You have always been there whenever we have sought your help. Eldrigu namaskara. Thank you.